Hello, and welcome to my webinar titled Protecting What You Have for the People You Love the Most. It's about estate planning, and hopefully my goal is to answer lots of important questions that you might have and answer some misconceptions out there. Let me give you a quick background of myself, though, to begin with. My name is Andrew G. Rosenberg, and I'm the owner of the law firm of Andrew G. Rosenberg, PA. We're located in South Florida. And I just want to give you a quick story as to why I have an interest in the estate planning field. It has to do when I was a little child. I grew up with three sisters and my parents, and two older sisters and one younger sister, Laura. When Laura was 9 years old, unfortunately, she got diagnosed with cancer, and I was 10 and a half at the time. We shared a room, so I was very close to my sister, and we grew up with cancer in the house. She ended up passing away from cancer at age 19, so I had about 10 years of growing up with that in my house, and I got to see firsthand what happens when you're not prepared and organized as far as handling an estate plan for a child and making sure that you can handle things properly. But I got to meet with an attorney when my family met with the attorney, and he helped us through that process, and that got me interested in the estate planning arena. But enough of me, let's get into the lecture. So first thing is, what are the 5 biggest misconceptions in estate planning, in my opinion? Well, the first one is, if I have a will and my assets are not that much, then I'm fine. I don't have any problems. Well, that's completely false. One thing I want you to realize is a will equals probate. A will guarantees probate. And that is the biggest misconception out there. That's one of them, at least in my opinion. And then the question becomes, I don't understand. I thought if I had a will that I don't have to deal with probate. And the question is, what is probate? Well, quickly, let me tell you what probate is. Probate basically is a court process that transitions when someone passes away and they own assets in their own name, in order to legally transition those assets from the person that passed away to whoever they want to give it to, they have to go through this court process. It's time consuming, it's expensive, it's public record. It's something you don't really want to go through if you don't have to. And that whole process is called probate court. And what happens is, at the end of when someone passes away and they have an asset in their name and they have a will, well, we go through all the hassles, delays, expenses of probate. At the end, the judge is going to say, well, where's the asset go? And then we look at the will to see where the asset goes. So a will guarantees you probate. And that includes if you even have small amounts of money. So, for instance, right now I'm handling a very small probate where someone forgot to put a bank account of about $8,000 in someone else's name, or however you want to do it, and that's going through the probate process, and it gets expensive. So the first misconception, a will is okay. That's not correct. Second misconception, in my opinion, for estate planning is, if I pass away with assets in joint tenancy, it will avoid probate as well. That's false. Joint tenancy is a type of ownership, just like there's ownership, different ways of owning property. Joint tenancy with rights of survivorship basically means that if I own an asset with my spouse and my spouse passes away, then the asset is now automatically owned by me alone. The problem is that when I pass away, then that asset is going to go through the courts because it's owned individually by me. So joint tenancy, people think that if you put an asset on with someone else's name, that's automatically taking care of things. That's not 100% correct, because what happens is joint tenancy is a probate delay tactic, not an avoidance tactic. Number 3 on the biggest misconceptions in estate planning is, I should put my kids on my accounts as a joint tenant. That's a definite no-no. That's a huge mistake. And the reason that's a huge mistake is for a number of reasons that you see on the slide. Number 1, what happens if I put my bank account and I name my child on the bank account with me as joint tenants? Well, the problem is that if that child were to get divorced, or if that child were to get into a car accident, then they were considered that, or those assets are considered part of that divorce, part of that car accident situation, or if you get sued or whatever it might be. So you don't want to do that, because you're opening the Pandora's box of issues with regards to having something happen to your kids, which will happen to that particular asset that you named as well on their account. Another issue with putting kids on the account is that it's a little complicated, but basically you lose what's called a step up in basis for tax reasons, which means that if the value when you bought it of the asset, let's say it was a stock, IBM stock, and it was worth $10,000 when you bought it. Now, when you pass away, it's worth $100,000. If you put the kids on the account, you lose all that $100,000 step up without tax avoidance. It's complicated, but that's something that we could talk about at a later date. So that's number 3 on the biggest mistakes. Number 4 on the biggest misconceptions out there is naming my child as a beneficiary of my will, life insurance, or retirement plans when they're under the age of 18. That's another major mistake. In Florida, if your child is under 18, they are considered a minor. If they were to receive the asset, meaning you named your child as the life insurance beneficiary and they're 16 years old and you passed away, that asset is going to go through what's called guardianship court. And that is something that you definitely don't want to go through. There's 2 types of guardianships typically. There's a guardianship of a minor, and then there's a guardianship of an adult. The guardianship of a minor is what we're talking about here, which is basically where if someone is under the age of 18 and they receive an asset, they cannot control that asset because the courts of Florida say that they're not an adult yet. It will have to go through the court system, very expensive. That court system is called guardianship court. Once they hit 18 years of age, then they're considered an adult. The other type of guardianship is when someone is over the age of 18 and they are unable to handle their financial affairs. Typically, an older person where they just have lost their faculties and they're not able to handle themselves. So then there's a guardianship for that as well. But the 4th biggest misconception out there is naming your child as a beneficiary in your will, your life insurance, or any other retirement plan, and they're under the age 18. Number 5 on the biggest misconceptions is thinking that you're too young to do an estate plan. That, in my opinion, is a mistake. There is more to estate planning than just a will. People think estate planning is just doing a basic will. That is completely false. There's lots of other documents that are involved. We're going to talk about them in a little bit, but just to name them, there's a durable power of attorney, there's a healthcare surrogate, there's a living will. And an example I want to talk to you about is I have 2 kids that are in college. And so when they go to college, they're 18. At that point, they're considered adults. So guess what? I don't have access. If they're sick, I can't talk to the doctors. And if something happens, I can't have access to their accounts or whatever. So that's what these other documents, which I will talk to in a little bit, deal with. So it's really important to have, especially if you have kids. And you don't have to be 50 years old to do an estate plan. Remember, an estate plan is more than just a will. So what is an estate plan? Well, an estate plan is basically making sure your estate and the property that you have is leave behind how you want it to leave it behind. Making the right choices of what you want to happen to your assets or property when you become disabled and also when you pass away. It's important to remember there's 2 areas. One is when you pass away, but the other is when you become disabled. And that's an important area that people don't consider. Property, when I talk about property, it means basically your home, your bank accounts, your investment accounts, your IRA, your 401k, your car, your arts, your life insurance, your CDs. Anything that you own, that is an asset. At a minimum, what should you have in an estate plan? You should always have a will. The reason you want to have a will is if you don't have a will in the state of Florida, they will create a will for you with a statute. It's called the intestate statute, meaning the state is going to tell you where your assets go if for some reason you did not create your own will. So you always want to have a will. In addition, the will control where the assets go. Again, sometimes a will is not appropriate because you're going to have to go, like I said earlier, a will guarantees probate, and we want to try and avoid that. But some of the advantages of a will are that if you have children under the age of 18, the will be the document that names the guardian of who will watch over the kids when you pass away if they're under 18 at the time. In addition, certain wills will allow you to do what's called a separate writing document, which will allow you to give away what's considered tangible personal property, such as coin collection, gun collections. Maybe you have a wedding ring that's from your grandmother you want passed to your particular daughter, those types of things. So a will can do that as well. So at a minimum, in the will, the separate writing would do that. At a minimum, you want to have a will. In addition, like we talked about earlier, we want to have a healthcare surrogate, durable power of attorney, and a living will. In my opinion, that's a basic estate plan. There might be more needed, and I'm going to talk about that in a minute. But let's quickly talk about what all 3 of these documents are. Healthcare surrogate is basically a scenario where if you are unable to make your own healthcare decisions, the example I like to use is if you're in a car accident and you're unconscious and you're at the hospital and you have to have surgery, and the doctors say we can go one of 3 different types of surgeries, who's going to make that decision? You're not awake. You can't tell us what you want to do. The healthcare surrogate's going to name that person to slide up into the shoes to make those healthcare decisions on your behalf while you're unable to. That's a healthcare surrogate. The next is the durable power of attorney. That's the same thing as a healthcare, but it only deals with financial concerns. So if you're unable to handle your finances, that same car accident situation where you're unconscious, who's going to be able to write the checks to pay the bills and to talk to the institutions where your assets are, et cetera? That's the durable power of attorney. You name who you want there. And then the last document, which is extremely important as well, it's called a living will. I also call it a dying with dignity document or a pull the plug document. Or if some of you are old enough, you'll remember the Terry Schiavo case, the Terry Schiavo document. This is the document where you are telling us while you are alive and of sound mind whether you want to remain on life support or you don't, if you're ever in that situation. Now, what's important about a living will and what you need to understand is that the living will doesn't kick in until, number one, the doctors that are watching you and taking care of you determine medically there's nothing more that they can do. Then, if you have a living will, they look at the living will to see whether you want the life support tubes, et cetera, taken away or kept on. The biggest example I like to give is if you're in a car accident and you're on life support and the doctors have determined that medically that there's no brainwave activity in that situation, then the doctors are going to look to see if you have a living will or not. It's a very important document, especially because it lets you make the decisions, not your family, which takes a burden off of them. What about, you hear all the time about, do I need a revocable trust as part of the estate plan? And the number one point that you need to understand is that every circumstance is different. There are huge advantages to a revocable trust, and I'm a big fan of the revocable trust in the right situation. Number one, it avoids probate, which is what we've talked about in prior. We definitely don't want to go through probate. Number two, it also avoids guardianship if you're disabled. So that's great. In addition, it acts like your will in that it is the document when you pass away to distribute the assets. And then number four is that it can hold the money in trust for your kids or whoever you want to give it to. Instead of distributing outright to them outright, you can do it over stages of time. Most of the time, ages 21, 25, and 30 are a typical situation. So there's huge advantages of the revocable trust. There is disadvantages of the trust, although I think they're minimal. Number one is the time commitment to get the assets properly funded. There's two steps to the trust process. Number one is creating the trust, signing it, etc., getting it notarized. Think of that as like an empty box. The second step is called funding or populating the trust. That's a fancy legal term. All that means is filling up the trust with these assets. Anything in the trust, in the box, when you pass away or you become disabled, no problem. We avoid guardianship. We avoid probate. That process of putting things into the trust at the beginning can sometimes be a little bit burdensome, but we're here to help. In addition, it does cost more money to set up a revocable trust than to do just a basic will, but you're going to save a tremendous amount of money in the long run, as we talked about with the probate and the expenses, etc. Now, let's get into some other common questions that I always hear about that I thought would be worthwhile on the webinar. Number one, how is my property transferred at death? Well, as I said, there's different ways that it can be transferred. The first one is by law. So an example would be joint tenancy. Again, that's a situation where if you own it, husband and wife or brother, sister, or however you own things, when one person passes away, the other person will now own it automatically by law, outright. But then when that second person passes away, it's going through probate. Number two is if you pass away without a will, then it's called intestate. And then the state of Florida is going to determine how the property gets transferred. Number three is a will, which is what most people think about, and that will go through probate, remember, but it will distribute the assets. But again, it's got a lot of negatives because of the probate. Number four is the revocable trust, which will distribute your assets. Again, it avoids the probate and avoids the guardianship. Another common question, can I plan for my pets? I'm a huge pet lover. I have 2 dogs of my own. The answer to that question is yes, you can plan for your pets. There's special language and trust language that can be put into the documents called a pet trust, for lack of a better term, which can determine how your assets will go, or not how your assets, but how your pet will be watched after, how much money you want to leave behind, etc. There's lots of things you can do for a pet. Another common question: where should I put my estate planning documents when they are completed? Number one, do not, I repeat, do not put them in a bank safe deposit box unless you name the person that is going to handle your will or handle your trust, etc., so that they can get access to the bank deposit box. But I would highly suggest that you put that person's name on the actual bank deposit box as well, and they have signatory authority. Otherwise, in order to get access to that bank account where all the estate planning documents are, it's going to go through probate, and we have to have a hearing for it. So I don't like that, putting it in a bank safe deposit box. I think you're better off if you get a fireproof safe and put it in your house, and then make sure you tell the people that are in charge where you put the assets in your house. I think that's the better alternative, in my opinion. Another question: can anyone be the executor of my will? In Florida, the term is called personal representative, or PR. It's the same thing as executor, but that's what we call it in Florida. And the answer is no, anyone cannot be. Number one, if it is a relative, they can be anywhere in the world. So as long as it's a relative, they can be the personal representative or executor of your will or estate, as long as there's no felony conviction with them. Number two, if it's someone that's a friend or someone like that, then they need to be a Florida resident in order for them to be appointed as a personal representative. Or you can always name a corporation or a bank or other entity to be the personal representative. However, they're going to charge fees in order to go through that process when the time comes. Does a revocable trust protect me from creditors? No. There's a different type of trust called an irrevocable trust, which we're not going to talk about today. But the revocable, which does protect you from creditors, but a revocable trust does not protect you from creditors. A revocable trust gives you 100% control of your assets, just how you have them today. As I like to describe it as, there's a triangle of legal hats that you own, or that you have as a revocable trust. The first point on triangle is that you're the grantor or the settlor of the trust. You're the one that actually creates the trust. I might be drafting these documents, but you're the one that actually created it legally. The second point on the triangle is that you are the trustee of your trust, or manager. Just like you manage the same affairs today, you manage the same affairs in the trust. And the third point on that triangle of legal hats is that you are the beneficiary of the assets while you're alive. So therefore, if you think about it, you have full control of your assets. So how's that going to protect you from creditors? It's not. This is not what it's meant for. That's why we have auto insurance, homeowners insurance, etc., to protect you. So that's what, number one, you need to understand. Number two, there is language for your kids or whoever you give as the beneficiaries of your estate called spendthrift trust language that goes into these documents that will protect them from a divorce, a lawsuit, etc., but it doesn't protect you. Again, does a revocable trust protect me from creditors? The answer is no. With this whole COVID-19 that we have going on, I have lots of questions on whether a will is the most important thing to have. My answer to that is a will or trust, I should say. My answer is that it's very important to have a will or trust, absolutely. But if I had to tell you, if you had to pick what's the most important thing with this COVID situation, it's that living will, that durable power of attorney, and the healthcare surrogate. Those three documents are really important right now, because think about it. If God forbid you're put in on a ventilator and the doctors and you've gone downhill and there's nothing more they could do, you want to have that living will taken care of. If something happens and you're unconscious and you can't communicate, we want to make sure that we have the healthcare surrogate for healthcare decisions and the durable power to take care of your financial affairs. It's important, very important, to have a will and a trust, but if in the COVID situation, at a minimum, you need to have that. Do life insurance or retirement accounts go through probate court? Hopefully not. The point of this is that you really need to make sure that your beneficiary forms are up to date and organized with your complete estate plan. Anything that has a beneficiary form, which is life insurance, retirement accounts, 401ks, IRAs, annuities, those types of accounts have a beneficiary form. That's where you need to put the name of who you want to give it to. Does it make sense to name a minor the beneficiary? No, because we talked about it earlier. There's lots of ways to plan accordingly to make sure the beneficiary forms are named correctly, but the goal is to make sure that it doesn't go through probate. If you named someone that passed away and didn't name anyone else as the beneficiary, or you named the estate as the beneficiary, that's going through probate. We don't want that to happen. Another question: when should I make updates to my estate plan? Well, I always tell my clients the best time to make changes or updates is when something major happens in your life. It might be a marriage in your family, there might be a death, a divorce, change in you move locations, you have a huge change in assets and inheritance, maybe you have a birth of a child or a grandchild, or this COVID-19 is a great example. This is an event, and this might be a situation where you should update your estate plan. Again, my goal today is to make sure that we all age with dignity, that you have options. You need to understand that in an estate plan, there's lots of options available, and that you identify who you want to make sure will take care of you and will help you manage your assets if you're unable to. And we want to make sure that you're in charge of your estate plan. With this whole COVID-19, I've gotten tons of calls because people are really worried, obviously, with good reason. So you've worked really hard to have what we have. I know I've worked really hard, and you want to make sure you leave a legacy for the ones behind. That's why it's really important to have an estate plan. I hope you appreciated this webinar. I look forward, we will reach out to you in the next 24 hours or so to touch base with you to get a consultation set up. Or if that's too long and you really want to set up a time, do me a favor, there's a phone number below, 954-755-7803, where you can call us and set up that Zoom call, face-to-face now we're allowed, or telephone call, consultation, whatever works for you. I look forward to hearing from you. In addition, you can email me at andrew@rosenberglawfirm.net. I hope you found this worthwhile. Thank you.